Good morning. It's Monday, January the 29th, 2024. Welcome to the 19th session of the Canadian International Internet Dispute Resolution Center, or CIDRIC. I'm Ina Ergasheva, the Director of Operations and your moderator today. For those new to CIDRIC, among only 6 ICANN-approved providers worldwide, we are the only one in Canada. CIDRIC is a division of the Vancouver International Arbitration Center, or VANIAC, a nonprofit administrator of domestic, national, international, and international commercial disputes, with almost 40 years of a trusted and efficient service record. Our panel today is truly international. CIDRIC is pleased to feature panelists from 3 continents and 5 countries: France, Germany, Italy, Venezuela, and Switzerland. This is a special session where we will aim to shed light on women's contributions to the domain name dispute resolution field. In the next 60 minutes, you will hear personal stories, gain insights into challenging cases, discover intriguing statistics related to women in UDRP and URS, among other topics we hope you will find interesting. The slides and recording from this session will be forwarded to you shortly after the session. And now, I will now invite in alphabetical order each esteemed panelist to introduce herself. Following the introductions, I will pose questions to each of our distinguished panelists. It is my honor to start with Nathalie Dreyfus, a pioneer in the field of domain name dispute resolution. Nathalie.
Thank you, Ina, and good afternoon from Paris. I am a French and European trademark attorney, specialized in IP and IT. I'm the founder and managing partner of Dreyfus in Paris. It's an IP law firm boutique. I'm also an adjunct professor at the French National School of Judges. Well, my daily works involve protecting, defending trademarks, designs, copyrights, domain names, plant variety, and more. So at Dreyfus, we operate in France and internationally. We also draft contracts, and we have extensive proficiency in all issues relating to the internet and new technology. So it includes phishing, cyber squatting, any matter regarding social media, domain names, NFTs, Web3, online sales platforms. So I have also published several books and write articles in IP and IT specialized journals. And I'm the editor of the Dreyfus blog with legal updates related to trademarks, patent, copyright, internet, and new technology. And I've been recently appointed as a certified judicial expert at the French Supreme Court for trademarks. And I'm the only woman and the only one in France.
Thank you very much, Nathalie. Very impressive. And now I would like to invite Stephanie Efstadhiou, one of our newest panelists. Please introduce yourself.
Thank you, Ina, and thank you also for inviting me to this wonderful seminar and webinar. My name is Stephanie Efstadhiou, and I'm happy to be among such amazing women in the UDRP. I am an alternative dispute resolution and IP lawyer, and I serve also, as you rightfully mentioned, as a domain name panelist for various dispute resolution service providers around the world. One of it is CIDRIC. And I am also dual qualified in Germany and Greece. I'm holding 3 LLM titles. All of these were focusing on international law and international arbitration. And I'm also in the process of finishing my PhD this year that is also focusing on AI and arbitration. So as you mentioned, yes, I'm one of the newest panelists for CIDRIC, and I'm very happy also to be here and talk about women's future in the UDRP.
Thank you, Stephanie. We're very happy to have you. And now we will move to Claire Kowarski. Welcome, Claire.
Thank you, Ina. It's an absolute pleasure to be here this afternoon. My name is Claire Kowalski, as you mentioned, and I'm a co-owner of a majority female-owned IP boutique consulting firm, HSS IPM, here in beautiful Switzerland. I am a dual qualified Australian and Texas lawyer. I recently took the bar exam and became qualified in Texas. And I lead a very strong female-centric team of lawyers, amazing lawyers around the world with HSS IPM. I'm a panelist with Cedric, and it's a pleasure to be here. And I'm also a panelist with another provider around the world, and I've been working in domain name dispute matters since 2016. Perhaps most importantly, and one of the reasons I'm very interested in the discussion today, is I'm a mother of two wonderful daughters, and so women's issues are very close to my heart and close to my family's heart.
That's fantastic. Well, I'm a mother of two boys, so we'll balance here. Now, our next presenter is Alejandra Maria Lopez Garcia, or Alex.
Thank you, Ina. Well, my full name is Maria Alejandra Lopez Garcia.
Oh.
But yes, don't worry. It's okay. Usually my international colleagues call me Alex. That comes from my time in Switzerland. But anyway, so I qualified as a Venezuelan IP attorney since 1999. I run my own law firm, which I established in 2017, named IPRs Online, which is exclusively focused in IP and infringements and on internet related with intellectual property, specifically with basically or mostly with trademarks. I've been working with I've been in the domain name field since 2007, and I also finished my LLM with the Alicante University. So that's me. Let's say that I'm a mother of a beautiful Dutch hound and two cats. and that's it about me. Okay, thank you very much.
Thank you. Oh, that's great. And the last but not least, Yvette Pavlovich. Yvette, welcome.
Thank you very much, Ina, and hello everyone. I'm a dual qualified lawyer in Hungary and Italy. I'm based in Milano, Italy, in the northern part. I am a UDRP panelist for CIDRIS and also for other providers in Europe and in Asia. And I'm also the case manager of the Uniform Rapid Suspension domain disputes for the European provider. And since 2020, I've been working as an external consultant for the European Commission on domain name issues, conducting several studies on domain names.
Fantastic. So we have an incredible women gathered here today, and it's absolutely great pleasure. So let's, without further ado, dive into learning a little more from each of them. And I'd like to start with Claire. Claire, I understand that the HSS IPM team has reviewed, just listen, around 8,000 UDRP decisions. I can only imagine what amount of time you spent on your team, as well as reviewed the panel compositions of domain name dispute providers around the world to gain insights into women's contribution to the field. What are the key findings from this research? Claire, please share, and I know you have slides. You're on mute, dear Claire.
My apologies. I think you can all see my screen. I just have to do, first of all, a huge shout out to Fernanda Zaragoza Benitez and Christy Grabovari from my team, who were part of this huge research project that we've been working on the last years. As Ina mentioned, we looked at 8,000 decisions, and today is the first time our findings are going to be shared. So this is a world exclusive. So what we wanted to do is when we started talking about the topic, I wanted to actually find out how are women working in the UDRP, and what involvement do women have in the decision and the decisions that are being made and influencing the jurisprudence. So we went back, and WIPO is the organisation that was initially providing UDRP services, and we went back to 1999 was the first UDRP decision published, and in that year there was only one decision, and that was decided by a male. So we started looking at 2000s, and in the 2000s, in February, we found the first decision that was made by a female panelist, Sally Abel, and she actually denied that case. So that was an auspicious start to the female jurisprudence. The first time that a woman was involved in a 3-panel decision was not until July of 2000, and then not until 2001 that we had a 3-member panel with 3 women on it. And I think we're very fortunate today to have Ms. Dreyfus on the panel, as she was one of the original panelists with WIPO back in 2000 when it all started. Then the next thing we wanted to look at, we looked at, we had a good body of decisions in the year 2000. This is where we get the 8,000 decisions that we actually reviewed. Back in 2000, there were 1,800 decisions, of which there were about 1,800 filings, of which there were about 1,500 odd decisions, because of course not every case reaches a decision. A significant proportion are settled. And out of those 1,500, about 106 were decided by female panelists, and that represents about 13.8% of decisions back in 2000. And then we wanted to see, what has changed since that day. So that was, when the UDRP was in its infancy. Is anything different today? So we started looking at 2023, and then we realized that there were like 6,000 cases to review, and my team and I nearly killed ourselves going through all of these. But, there were about 5,300 odd decisions during that period, of which 1,198 were from female panelists, and that represents about a 22% share of the decisions. So you can see that the trend over 23 years has increased somewhat to, about 20%. And then we wanted to have a look at, looking at all the panels around the world. As Ina mentioned, there are 6 providers. What is the breakdown of male versus female panelists on those? And WIPO has the biggest panel, and you can see that's 487 panelists, of which about 21% are women. And then the next biggest would be the Forum, which has about 22. And total across all the panels is around 22%. So that tracks very closely with the decision profile from 2023, from those 6,000 decisions, where we had about 21%, 22%. So the number of panelists is aligning very closely and tracking to the number of panelists that are out there. While we were doing all this research, we found a few fun facts. Out of WIPO publishes what the cases which are most cited according to WIPO decisions, and out of the 25 most cited decisions, only 3 of those are coming from female panelists. So that's Anna Garibaldi, Linda Brown, and Madeline de Kock-Booning have 3 decisions that have been strongly cited in the jurisprudence. The other thing that we thought was quite interesting is that the Hong Kong International Arbitration Centre actually has a feature where you can filter panelists by gender, and reading on their website, it appears that they are actually really engaged with the topic of female and diversity among panelists. And with that awareness, they include a filter mechanism, so you can see what decisions are coming from panelists. Whereas in the case of the other providers, we actually went through and manually counted, like we went to every decision and looked at who the decision maker was to determine whether it was a male or a female. Another area that we thought was really important to consider female involvement is the latest UDRP policy status report from ICANN, where they invited submissions And we thought, we wanted to see how active are women in the discourse around the UDRP. And in this case, there were 44 submissions received by ICANN, but the greater proportion of those did come from men. And one of the things that we found to be very interesting is that when there was a comment letter included with the submission, only 1 out of the 13 women who were representing organisations actually signed the letter, whereas 4 out of the 19 men representing organisations signed it. So while women are definitely involved in the discussion, they are coming forward less, putting their name, putting their title, putting themselves as an author to these submissions. Obviously, it's a small sample here that we're looking at, but we thought perhaps there's something in that with the women being involved in the discourse, but less likely to give themselves as use their own name to that. So that was the research that we found.
Thank you very much, Claire. And now we will move to Nathalie. Nathalie, it's a privilege to have you here with us today, considering your involvement in the field since its inception. So please share with us, how did you become a UDRP panelist?
Well, it's my pleasure to be here, and thank you to invite me. So yeah, I was one of the first women panelists appointed by the WIPO back in 2000. So because, as Claire just said, WIPO was the first center in charge of administrating the UDRP. So you may ask me why. Well, at that time, I was already well known in the industry, because before 2000, in France and in the world, the defense of intellectual property rights on the internet was a new matter. So very few attorneys were advising their clients to defend their trademarks on the internet. And I was one of them. And it was before the UDRP was launched end of 1999. So back in 1995, I already explained to trademark owners that defending their trademarks in the real world was not enough. And the internet was becoming commercial, and trademarks needed to be defended also on the internet. It seems obvious nowadays, but at that time, it was very advanced. So I was invited to sit at the table on the discussion to set up a special procedure to tackle cyber squatting, and it was the UDRP. So the discussions took place in Geneva at the WIPO, and there were representatives of trademark offices, trademark owners, on internet industry, and they were all present. And I thought it will be very difficult that they understand each other, but a miracle happened, and the UDRP was born. And so, as Claire just told us, the first decision was in December 1999, and that's how I got involved as a panelist. Sorry, Ina, we can't hear you.
Sorry, I was on mute. Yes, thank you very much. It's incredible. Thank you for sharing. And maybe, do you remember a challenging case when you started?
Yeah, so Claire was talking about the 3-panelist UDRP, and I was invited to sit on a 3-panelist UDRP in 2002. So it involved the French TV channel France 3 against South Korean domain name registrant Kwon Kim. I don't know if I pronounce it well. So you had Professor John Sun-yo was appointed as a panel chairman, and I was a panelist with another Korean professor, Professor Ji-Suk Woo. So in this case, well, France 3 is part of the French TV group on its own. It owns a trademark France 3, which is broadcasted in the world through cable, especially in Asia. And the domain name was used for pornographic content. And the respondent wanted to sell it indirectly for more than $100,000 US. So the respondent claimed to have a right and legitimate interest in the domain name because it was a common name like France, the country name, on a number, mere number 3. But this was a challenging case because it was a refiling for a dispute where the applicant, respondent, and dispute domain names were the same. So the requirements on legality of retrials are not explicitly stated in the UDRP, and there were no case law at that time. So we decided to apply the general civil procedure rules regarding retrials in court. So we had to decide if some materials on credible evidence were not known at the time of the first UDRP decisions. So we decided that the complainant did not provide sufficient new evidence, and there were no case for a retrial. And so we dismissed the application for retrial in this case. So it was very interesting and challenging for us. And besides, it was a pleasure to work with my colleagues from South Korea on this procedural issue.
Oh, that's fantastic. Yes, thank you. Thank you. Yeah, that's incredible. Do you see maybe if looking forward, looking right now and looking back from right now in the past and see the evolution, do you see any new trends in domain name abuse?
Yeah, it's evolving all the time. So and we see more sophisticated attacks like SMS-based infringements, fake websites, and they're all increasing, and also more complex phishing cases. It's a pleasure for me, and it's a commitment to contribute as a panelist to this dynamic world of domain name dispute, and I'm trying to give my experience on my expertise to navigate this complex legal waters.
Considering these changes and trends, in your view, do you see any changes in UDRP complaints?
It's a good question, so I think there are significant increase in the number. Well, it's a fact. There's a significant increase in the number of complaints that are filed, and but there's also a rise on the number of complaints that are rejected, and I think this is because of a lack of understanding of the UDRP by complainants or their representative. So I have noticed as a panelist that some right holders, in some cases, attempt to misuse or manipulate the UDRP for their own benefit. And because the UDRP, it functions very well so the increase of rejection, I can explain, according to me, because of this misuse and procedural abuse. Another thing is that what I see is that majority of the complaint, they request transfer of domain name rather than the cancellation of domain name. So you may ask why, because in the past, in 2000 till 2010, it was more cancellation. So the primary reason is that, as you know, when a domain name becomes publicly available again, it is quickly re-registered, and so it can be used for fraud and misuse again. So typically, complainant requests direct transfer of the domain name to avoid that it become available again. And I have also noticed that some centers approach this kind of request of cancellation with caution. And when they receive a cancellation request, they will inform the complainant or its representative about the risk that the domain name will be re-registered and become if it becomes available again. So I have seen some complainants convinced and changing the remedy requested from cancellation to transfer. What else did I see? I see also what I see as a panelist is a lack of substantial content in some complaints. What I want to say is that some complaints are purely drafted, and it is often the case when it is vendors like a registrar that draft complaints instead of attorneys at law. And these poorly drafted complaints, they can really reflect badly on a company. And I think it's very important to be represented by a lawyer on a UDRP. And speaking from experience, a weak case file is really a disadvantage because a panelist is limited to the information presented in the complaint and they cannot consider unraised arguments. Well, at least for me, because I apply civil law and not common law. So this limitation can really lead to unfavorable, I would say, decision. And another observation, it's more on the first condition of the UDRP. It's about the domain name identical or confusionally similar to a trademark. So what I see that some complaints, they do not provide really proof of that trademark rights. Proof of a trademark rights for me, it's a certificate, a trademark certificate, and if the trademark is due for renewals, proof of renewals. I mean, a simple listing doesn't show a trademark rights. So, and also we can see that some complainants, they rely on trademarks that are not used. So they could be challenged for non-use if there is an appeal. And so for this could lead, I mean, to rejection of a complaint and could be put the trademarks right at risk. So me as a trademark specialist, I noticed this deficiency, but since the UDRP is designed to address fraud in domain name, I mean, these weaknesses can often be overcome. And of course, the quality of the case files on the decision can also depend on the dispute resolution center. And for example, of course, your center is noted for its excellent procedural standards.
Thank you very much for this insightful for your insights. That's very important. We do have lots of complaints, and some of them are self-represented. And yes, you're right. The poorly drafted complaints lead to outcomes which could have been avoided if all sufficient evidence are presented. Yes, thank you. And thank you very much, Nathalie. And now we are going to move to Alex and to different continents, different world. And Alex, could you share insights into how the Latin American market typically responds to domain name disputes? Yes. So you have your presentation. Thank you.
Yes. Can you see my presentation, everybody?
Yes.
Yeah?
Mm-hmm.
Okay, now I'm full. Okay, yes. Thank you very much, Ina, and thank you very much, Mrs. Dreyfus. I'm incredibly honored to be here with you to share this space. I'm sure that I will listen this recording more than once. And also with all of you ladies, UDRP ladies, to be here. Yes, in relation with how Latin America responds to domain name disputes, I have found that they are interested. They still see it as a new subject matter in relation with trademarks, but there is a but. I have found some obstacles which have made me think it is related with accessible professional fees in relation with the attorneys. If we have to consider that they have to submit themselves to a brand protection program, and also probably other studies, specific specialized studies in relation to the IP assets online. Also, if there's a need of cultural consciousness, what about the awareness that we as IP attorneys are doing and performing in relation to the trademark owners or towards the trademark owners? Because I have seen that some of them, I said that when you find an obstacle, it's like, oh, I move forward and I'm not going to insist, or I'm not going to provide IP awareness can take too much time, no? It's time consuming and also can be sometimes costly, but in my view, it is worth it to do that. It's specifically when there is such an effective a legal tool as the UDRP, and where there is certainly there are so many infringements online nowadays, especially after the pandemic, and also in relation with tailored assessments. We as lawyers, we consider that we do have to provide to Latin America this kind of awareness. This is very important in my view. But one question is important to solve. Is Latin America involved in cyber squatting, and what is it, how, in which way they are present? So I brought this geographical distribution of parties in relation to Latin America. That is, the source come from WIPO, which is all these numbers are public, and you can take a look after if you would like, in the statistics section. We can see that Argentina, these are numbers from 2023, okay? I mean, last year. Argentina is present with as a complainant and also as a respondent. We can say also that Brazil has a large number of complainants of 700 cases as a respondent, even more. We have to consider also the geographical extension and population of this country. Chile also have present, and also Colombia, I would say that is important. These countries, sorry, for example, they still do not, they're still on that pace, I will say. You can take a look at it afterwards, since these presentations are going to be distributed to each one of you. Mexico, of course, is there. Let's say also Panama, and it calls my attention that Panama in last year with 1,310 as a respondent. So we have to consider what's going on there. So who is the cyber squatters out there, certainly. Peru also, also Uruguay, and even Venezuela is there. Well, has been there always. Present since we acquired the UDRP as well. So in summary, I will say that from these 30 countries that I took to analyze, 15 of them were more present. But how can we see the future of a domain name, and also in relation with Latin America? If we have to consider, well, the numbers maybe are not so big as Europe and United States, but we have to consider these numbers, in my view, because it's gonna happen, and it's gonna still happening. According to Verizon, 359.3 million domain names registration across all over top-level domains have been registered by 2023. And if we consider this number from LATILD, which is a Latin American association which represents the CCTLDs, 10 millions, these are the numbers for 2020, 10 millions of domain names are registered under CCTLDs, and during the pandemic, more than 740,000 of domain names were registered in the region. And unfortunately, the region doesn't have the number, that there is no centralized data. It's not easy to find, to say, which is the cyber squatting statistics for trademarks in Latin America. That's a number that I'm gonna work on, but it's not, it's not centralized. And if we do have to dig deeper or give more thoughts in relation to this, for example, we can take a look for some numbers that a Russian company dedicated to cybersecurity. There's a multinational, Kaspersky, according to 2023, phishing increased 6-fold in Latin America, and they detect 286 million phishing attempts through their softwares. And if we also can consider other Latin American associations, CISO, which has an agreement with the Duke University, which is new, but it's an interesting association in my view. that, for example, with BID in the financial sector, the region received, the statistics says that they received more than 1,600 cyber attacks per second. And we have to consider that cyber squatting, phishing is one of the scenarios, in my view, that I have seen with more frequency, I will say, and also the suspicious websites. Also, and on the first 6 months of 2020, according to this company, global ransomware distribution reached 384,000. According with this report, Brazil and followed by Mexico, Colombia, and Peru were the more the countries who received more attacks. Then there is another company dedicated to digital risks that is from Brazil, which provide, according to this last report, 2023, and also the view for 2024, which I'd invite you to review, is the data leak credentials reaches 4.2 billion that were filtered in 2023. Also, the use of AI to commit different or more sophisticated to manipulate the system in order to fall into attack that is used has increased this number as well. Also, more than 31,000 phishing websites were identified. And also, it's important to consider the current and so sad political instability and between Ukraine and Russia, and also between Israel and Hamas, who has increased certain attacks with different companies. You can also, I invite you to review this report of them. So, and also in relation with TLDs with phishing purposes, the more used were .com, which is still one of the more registered. It comes with more registrations and also comes with more cases. If we take a look at statistics from different UDRP providers, .com, and according with this report, close with 32.9%, followed by the XYZ, and then .online, .com, .pr, and .site. So I would say that in Latin America, yes, there are challenges, but also there are opportunities, in my view. But we have to consider as challenges can be the digitalization level of all the countries. Not all the countries have access to internet, but it's increasing, in my view. We have to consider that Latin America has used to be more reactive than proactive. So trademark holders used to take actions once the infringement is there. So unfortunately, still there is awareness to do. Also, as a challenge, they require specialized education in terms of a good cyber hygiene, in my view. So in companies, people understand how they can be trapped into a phishing scenario. Also, what is ransomware, malware distribution, the social engineer, distributed the denial of service, the DDoS, used to known as DDoS attack. So how they function, and also the use of AI. So what is the education that they are receiving concerning this? This is important. And awareness, basically awareness, and have to be, in my view, linked with IP, directly linked with IP, of course, with trademarks. Consistent awareness in terms of brand protection and ROI, which can be seen as even more new, or like it is an information that comes from space, but it is real, and it is important, and it is worth to take actions in relation to these services.
Yeah, thank you very much.
Yeah.
No, sorry.
Yeah.
No, go ahead.
Sorry, as an opportunity, I would see that IP and domain name education to adopt safe online practices, and also digital risks, tailored assessments to expand. It's an opportunity for IP law firms to expand legal services offered to TM clients, And so it's important. I will invite all the IP attorneys to always, especially in Latin America, that it's important to make them see the problem, even when that is necessary, especially a study as it can be the void. Yeah. So these are my slides, and you will receive afterwards. And well, so that's it. That's part of my contribution as a woman fellow in the UDRP.
Yes. Thank you very much, Alex. It's actually the numbers and statistics you presented. It's quite impressive. Speaking about the data lake, and I tried to make a quick calculation just for the duration of our session. If my math is accurate, we already had like over 3.5 million of attacks. So this is important to raise the awareness. So thank you very much for gathering these statistics. We received a couple of questions, but before we address them, and from Stephen Levy, actually also one of our distinguished panelists, and we will definitely address your questions, but I would like to give a chance to speak to our Yvette and Stephanie, and then we will definitely address the question. Now, Yvette, my question to you would be, do you have in mind an international instrument that aims to improve the representation and involvement of women in domain disputes? And do you have any statistics in the context of the uniform rapid suspension domain disputes? It's another alternative of UDRP. It's a smaller scale, but also very interesting tool. And what in terms of Europe, if you can shed light on this?
Thank you, Ina, for these interesting questions. And let me share my screen with you, because for the statistics, I think it's better if you can see the numbers. So can you see the slides?
Yes, very well, thank you.
Thank you very much. So yes, as for an international instrument, I have in mind the equal representation in Arbitration Pledge, the so-called ERA Pledge, that was drawn up by the international arbitration community in 2015, in recognition of the underrepresentation of women on international arbitral tribunals. Of course, I'm here speaking about arbitration, but this is something that can be relevant also for domain name disputes. So I included in my slides also the link to the pledge, if anyone wants to have a look at it and be a signatory of the pledge, which has two objectives. The first one is to improve the profile and representation of women in arbitration, and the second one is to appoint women as arbitrators on an equal opportunity basis. To achieve these objectives, the signatories commit to take steps to ensure that, for example, committees, governing bodies, and conference panels in the field of arbitration include a fair representation of women, which I think is very important, because we frequently see panels that are full male panels, and there are a lot of talented and prepared women arbitrators, and also domain name panelists. So it would be great to have always women on panels, also for training courses, for examples. Then for arbitration institutions, they commit to include a fair representation of female candidates on their rosters, and where there is the possibility and they have the power to do so, appoint female arbitrators. and also to make some gender statistics for appointments publicly available, which is very important. And unfortunately for the domain dispute providers, I couldn't see these gender statistics publicly available on their website, even though Claire mentioned that, for example, the Asian Domain Name Dispute Resolution Center in their tool for searching decision makes it possible to look up for females based on genders decisions. Am I right? Or only for, not for the decisions, maybe only for the
Yeah, only for the panelists, not for decisions.
Okay, so sorry for this error, but at least this is something more respect to maybe what other providers have. And also the signatories commit to support and mentor, sponsor women to pursue arbitrator appointments and to otherwise enhance their profiles and practice to reach their career goals. Today, the pledge has 5,500 signatories among organizations and individuals around the world. And on behalf of the European provider for the URS disputes, I signed this pledge because I considered it really important to commit to something in order to improve the representation of women in arbitration. So in this context, URS, just a quick recap, what is that? So it's a right protection mechanism implemented in 2013 within the new GTLED program. It's a trademark-based domain name dispute resolution policy, but it's important to highlight that it's only for clear-cut cases of cyber squatting. The disputes are decided by so-called examiners of 3 ICANN accredited providers. And I'm representing the European one, which is called MFD. Then there is Forum and, of course, also the Asian Domain Name Dispute Resolution Center. Here you have also the link for the policy. As every domain dispute resolution policy, it's also for the CCTLDs, of course. There are some advantages and limitations. One of the advantages of the URS is the duration. So it's quick, in 25 days maximum. There is a determination, and the costs are lower than for a UDRP. There is also the possibility to have an appeal. And as I mentioned, there are also some limitations. So it's not applicable, for example, for .com and for .net domain names. It's applicable for new GTLDs, to certain legacy TLDs. Since 2019, it's also applicable for .org, .info domain names. But complainants have to be reminded that there is a stricter burden of proof, so there has to be clear and convincing evidence in order to obtain their relief, the suspension, because the other limitation is that the only remedy can be the suspension of the domain name. There is no transfer. And here you can see an example. So this is a before and after screenshot of the domain name as it was before the filing of the complaint, and after the decision, when it's suspended, it is taken down and there is a message that the site is suspended. So within the context of the URS, my numbers are, of course, representing a very much smaller sample than the work that Claire and her team did. So we in MFSD we had 152 URS cases filed. The decisions that were issued up till now are 137. There are 6 pending cases. There were 9 dismissals where no examiner was appointed. This is because complainants filed URS complaints for example, for .com domain names. We have 32 examiners on roster, and of this we have 11 women examiners, so this represents the 34%. The number of the women examiners appointed to the cases were until today 43. So it's the 31%. And in 2023, during the week of Black Friday and just before Christmas, we had several filings. So we received 29 cases, of which 9 was decided by women examiners. So 21%. We added, since the signature of the Arab Pledge, 5 women examiners. So this could be the result and our commitment for the signature. So thank you very much.
Yeah. Thank you very much, Yvette. One thing it's important to mention, I'm very pleased to say that CIDRIC's parent organization, the Vancouver International Arbitration Center, is a signatory to the pledge. And our proactive board made sure that we are also on board with this. So thank you very much for your commitment and for the explanation of URS, very intriguing tool when it comes to resolution of domain name disputes. And last but not least is Stephanie. And Stephanie has a very interesting information. So for aspiring female practitioners, and of course not only females, who wish to enter the world of UDRP, what advice would you offer to help them navigate and establish themselves in this practice? Stephanie.
Thank you, Ina, and I'm happy that you're asking this question. For this reason, I have prepared also some slides, and I will share it now. And I believe you can all see it.
Yes.
Right. So I call it a step-by-step guide into the world of domain name dispute resolution. And I have gathered some information, as you mentioned, also not only for women that want to get into the world of the UDRP and domain name dispute resolution, but also for aspiring and interested practitioners. However, I have included in the end also a small section for women only, you will see. So starting with, I think, wait a minute. Yes, now. So starting with something motivational and optimistic, I also live by that motto that the future is bright and female, and I do believe that we need more female and women participation in basically all the sectors in the world probably, but also in the UDRP as we are talking about it today. So here are some of the opportunities for practitioners, and it's important to understand also when someone does not have an IP background or a background previously in trademarks mainly, that the UDRP and domain name dispute resolution is also about trademark law. So first of all, it should be that someone enhances their IP background, and there are certain opportunities to do so. First, for example, there are online courses for the basics. Someone can start with that. For example, there are online courses and platforms like Coursera, Canvas, or even the specialized courses from EU IPO and WIPO, and they also offer practical workshops. The second would be the INTA trademark basic series, where trademarks are explained extensively. Then the third would be specialized LLMs and university courses. If one has the opportunity to do so, then this gives a bigger insight into the world of IP. Here to mention, for example, there is the Queen Mary Law School in London, for example, that has a quite tailored LLM for IP. Then there is also courses and seminars from chambers of commerce or bar associations. For example, the Bar Association here in Munich provides also for several times during the year seminars for IP related topics, but also for domain name related topics. Then we would have the second step, where after having the IP background and having a knowledge in IP, I would say we should get into more depth in the domain name dispute resolution sphere. Here, first step would be to visit the ICANN website. As ICANN is the organization that oversees the internet, it is actually a quite vast website, I have to say, and you can get easily lost. But the first click, when you click on ICANN, there is a button that says ICANN for beginners, and there someone should start. There are courses under these sites. And you can also see an engagement calendar where you can see what are the meetings of ICANN and where you can get, where you can attend several opportunities that ICANN provides for. Then there are also training series of ICANN. Under this website of ICANN for beginners, there are several, let's say, explanatory webinars where it is explained what ICANN is, what it does, and then it is also explained what the UDRP is, or domain name dispute resolution in general. Then there are, the second step would be to have ICANN, to attend an ICANN public meeting, and they are happening throughout the world, but also online during the year several times. So it doesn't matter if it's a policy forum or something else, but it is a great point to start and also meet the community. Then a third point would be to have training sessions on the UDRP proceedings by dispute resolution providers or national registries, as there are some that provide for such option. There is also, when someone is a little bit more advanced and has covered all these steps, the WIPO Advanced Workshop on Domain Name Dispute Resolution, and this indeed goes quite into depth, and it explains and analyzes also case law. And then also, as I happily learned, there is the CIDRIC annual training that will be probably provided, as you mentioned to me, Ina, before, from by the ending of the year and on. So it is coming soon, so stay tuned, whoever is interested in that.
Thank you very much. Oh, sorry.
No problem. Then there is only the last point that I would like to mention is that, and I tailored this a little bit more to women. However, most of these points apply also to other practitioners and not only female practitioners. Mentorship and having a mentor is very, very important and very also basic in this industry. I would say myself, I had a mentor when I first started getting into the domain and dispute resolution sphere, and it was basically the also one thing that I could never imagine how far it would get me, and this was the important step for me to succeed in this world, I would say. And mentorship is very often found in different organizations. However, there is a disclaimer beforehand. There is no tailored mentorship program for the UDRP or for domain name disputes itself, domain name dispute resolution itself. But some women can find also other women that may be involved in IP disputes, IP arbitrations, or in the domain name dispute sphere. In the Arbitral Women Network, they also have a mentorship program, and I believe it's twice a year if not once a year, that they take applications. Everything is on their website, but it is mainly and tailored to women, women for other women. So this is a great opportunity to start from there. Then you can have mentors at work, where whoever is in an environment where women mentors exist in professional environments and are dealing with IP disputes. This would be also a great opportunity to have such mentors. Then there would be also mentors in the dispute resolution community, also in the broader dispute resolution community, not only in the domain and dispute resolution community, and mentors from your professional network. Here, I would like to mention that sometimes people approach me through LinkedIn to ask me about the domain and dispute resolution world. And often there are also women, so I'm always happy to help. And I would also like to here maybe publicly say that if someone wants to approach me and so that I can help with tailoring probably their path into this world, I would be happy to. And yes, I think that's from me, and I would thank you.
Thank you very much for this detailed step-by-step roadmap to how to get into the field. And as we bring this session to an end, I promised Steve Levy, and I won't keep my promises, address this question, and I will address it to Nathalie. And if Nathalie, and this is a big question, can in a couple of minutes, maybe 1 or 2 minutes, to explain or to say your thoughts on why the quality of complaints has deteriorated, and especially included, Steve Levy wrote, included in my question are complaints filed by law firms who claim to specialize in IP law. So Nathalie, what are your thoughts on this?
Well, I think I already addressed a little bit the question. It's a question also. Yeah, I think that yes, some complaints we can see, and I think that my colleague panelists probably agree with me, are poorly drafted on probably because now there's like a devaluation of the work that can be done on UDRPs. So question of cost and pressure on cost from companies probably. So I think there's yes a big competition on cost, which show perhaps that some law firms, they don't have time to enough time to make the effort to draft it properly. Some vendors, they don't know enough. I mean, and also it's a question of liability. So I think that Steve will agree with me that we are regulated by law as a legal profession, which is not the same that vendors or like registrar or any companies like doing watches or searches or on trademarks. It's not the same than to be a qualified lawyer and to represent a client in a UDRP.
Yeah, thank you very much. Well, that could be a topic for a completely separate session. So as we bring this session to close, I would like to extend to my sincere gratitude to each of you, Nathalie Dreyfus in Paris, Claire Kowarski in Zurich, Maria Alejandra Lopez Garcia in Caracas, and Stephanie in Munich, and Yvette in Milan. Thank you very much. Your contributions are greatly appreciated. Thank you for highlighting the role of women in this dynamic field. And as we promised, all the slides will be shared with you shortly, and also a recording will be available. Stay tuned. Follow us on LinkedIn and X, former Twitter, for further announcement, and we hope to see you, to welcome you in person in Vancouver this fall. If you need any further information, visit our website, ciidrc.org, or just give us a call, and our professional staff team will be happy to assist. Thank you, and have a wonderful week ahead. Grateful. Thanks a lot.
Thank you.
Thanks for everybody. Bye-bye, everybody. Thank you.
Bye.
Thank you.
Bye.
Bye.